Every intervention in the family court begins with a single binary question. Does a legally valid adult relationship actually exist? This distinction is the critical threshold. It separates couples who have standing to seek legal intervention from those who do not. Without a legally recognized union, the expansive property adjustments and financial maintenance orders of the family courts remain completely inaccessible. Securing this validity requires strict, unwavering compliance with two specific legal pillars. The first pillar is the rules of capacity, also known as essential validity. The second pillar dictates the rules of formation, referred to as formal validity. This dual-pillar system is not static. Modern statutes have redrawn these boundaries, granting legal standing to groups previously excluded from the system. The Marriage Same-Sex Couples Act 2013 stands as a prime example of a statute that rewrote this legal architecture. Understanding the precise mechanics of these two pillars and the modern statutes that modify them is the only way to predict whether a union will withstand judicial scrutiny or collapse into legal irrelevance. Capacity, or essential validity, forms the legal baseline. This is determined strictly by the individual's domicile. In England and Wales, the Matrimonial Causes Act 1973 provides the primary framework. The first hurdle is age, governed by the Marriage and Civil Partnership Minimum Age Act 2022. Both parties must now be strictly 18 or over. The law permanently removed historical exceptions that previously allowed 16 and 17-year-olds to marry with parental consent. The second hurdle tests for prohibited degrees of relationship. The law applies absolute bans on consanguinity, close blood relatives like siblings or first cousins. However, it applies conditional bans on affinity. Step relations face specific legal barriers depending on age and family dynamics. The third hurdle is the absolute prohibition against bigamy. Neither party can be currently married or in a civil partnership at the exact time of the ceremony. If a person fails these domicile-based capacity tests, they lack the fundamental legal power to form a union. Any subsequent ceremony they participate in is legally meaningless. The second pillar is formality. Formality is strictly governed by the laws of the jurisdiction where the ceremony takes place. For marriages celebrated within England and Wales, the law requires a universal set of civil preliminaries. This includes the mandatory procedural step of giving formal notice of marriage at a district registry office at least 28 days prior to the event. The law also tightly regulates the acceptable forms of ceremonies. Anglican religious ceremonies follow distinct historical rules, such as the publication of bans. In contrast, civil ceremonies and secular marriages face strict locational requirements. Venues must hold explicit municipal licenses to host a legal ceremony. We can see the absolute rigidity of these venue licenses in a highly publicized real-world example. When Prince Charles prepared to wed, Windsor Castle lacked the civil license. They were forced to relocate to the municipally licensed Windsor Guildhall. By successfully completing the civil ceremony at the Guildhall, they complied with the strict formal validity rules. Precise adherence to municipal location licenses and procedural timelines is just as critical to validity as the couple's underlying capacity to marry. The Marriage Same-Sex Couples Act 2013 restructured this legal architecture to incorporate a broader demographic. The act modified the rules of capacity by legally recognizing the right of same-sex couples to marry in England and Wales. However, even as it expanded capacity, the act carefully maintained the distinct procedural formalities already established in the law. It implemented an opt-in mechanism for religious organizations, allowing them to legally solemnize same-sex marriages only if they explicitly choose to do so. The statute also includes a unique, explicit carve-out for the Church of England, stating it cannot be legally compelled to conduct or participate in these ceremonies. Furthermore, the Act embedded critical transitional arrangements within Section 9. Section 9 allows couples to formally convert an existing civil partnership into a legal marriage. The legal mechanism of this conversion is powerful. It retroactively treats the new marriage as having existed since the original date of the civil partnership. The 2013 Act proves that while Parliament can rewrite the demographic inputs for capacity, it meticulously preserves the structural dual-pillar framework. This leads to a critical investigative question. How does the family court classify unions when the rules of capacity or formality are breached? Defective unions enter the legal arena of nullity proceedings, where the court stratifies them into 3 distinct categories. Category 1 is the voidable marriage, governed by Section 12 of the Matrimonial Causes Act 1973. A voidable marriage remains fully valid in law until a court formally annuls it. This typically occurs due to compromised consent, non-consummation, or an undisclosed acquired gender. In the precedent-setting case of Hirani v. Hirani, a young woman faced threats from her parents, compromising her true consent and rendering the union voidable. Category 2 is the void marriage, governed by Section 11 of the same Act. A void marriage never existed in law due to a fundamental, incurable lack of capacity, such as bigamy or breaching the prohibited degrees of relationship. Category 3 represents the ultimate failure, the non-marriage or non-qualifying ceremony. We see this clearly in the case of Akhtar v. Khan. The couple underwent an Islamic nikah, but failed to complete any civil preliminaries, had no registrar present, and conducted the ceremony outside a registered building. The court found that this procedural failure was absolute. It bypassed statutory nullity entirely, creating a legally meaningless, non-qualifying ceremony. Earning a non-marriage classification strips the petitioner of any right to apply for financial remedies under the Matrimonial Causes Act, exposing the catastrophic risk of ignoring procedural formalities. Zooming out, the complete conceptual model of relationship formation becomes clear. Relationship formation operates as a precise statutory mechanism, governed by strict legislative requirements. Whether a couple is navigating a traditional civil ceremony, an overseas marriage, or the expanded frameworks of the 2013 Act, these foundational tests remain immutable. Assuming a relationship has legal standing without forensically verifying its underlying mechanics exposes practitioners and their clients to severe malpractice risks. Practitioners must rigorously audit both the domicile-based capacity of the individuals and the formal validity of their celebration. Human rights considerations, specifically Article 12 of the European Convention on Human Rights, continuously pressure and shape this framework. While Parliament will continue to evolve these laws to reflect society, the structural requirement for strict statutory compliance never wavers. Ultimately, establishing the strict legal validity of the relationship formation is the critical first step in family law practice, as it dictates the very jurisdiction of the court to intervene in the financial and legal realities of the separating couple.